Hi, California Trust Litigation Attorney Scott Grossman here, and today I'm discussing the second breach of fiduciary duty that may give rise to a trustee being removed. In an earlier video, I laid out a list of 8 different reasons, 8 different duties that a trustee may breach and be subject to removal. So in this video, what I'm discussing is removal because the trustee has a conflict of interest. Conflicts of interest don't often arise, but they do from time to time, and usually when they arise, they're pretty clear. Some common scenarios are where the trust owns a partial interest in a piece of real estate, and whoever it is that's serving as the trustee owns an interest in that same piece of real estate. So, for example, in that sort of setting, you may have the trustee as an individual who says, this is a good investment, I want to keep this property, it's rented, it's producing income, I don't want to change that in any way, shape, or form. That's fine for, let's say, the 30% of the property they own. And then you may have the trust, of which you're a beneficiary, that owns the other 70%, and that trust may say, well, now that the settlor has died, there's going to be an outright distribution of those assets. Well, if that 70% needs to be divided up among a number of kids, it's not at all uncommon in my experience for at least some of the kids, maybe all of the kids, to say, well, I don't really want to own a piece of some real estate, some fractional interest, I just want cash. So let's get this property sold. I'm not interested in a fire sale, I just want to do what's commercially reasonable. Let's get a real estate agent, let's get this thing on the market, let's sell it for whatever fair market value is. You know there are going to be costs of sale, but whatever the net number is, that's what the kids typically want. Well, if the trustee says, I'm not going to do that because that's not what I want for myself, I want to hold on to this property, there's an obvious conflict. The trustee is trying to be on two sides of this, taking diametrically opposing positions. So it's just not possible. You've got a conflict of interest. Another place where this sometimes comes up is where there has been a failure to fund subtrust. So if your parents had what's commonly referred to as an AB trust, and that's really just some lingo that means when the first of your parents died, the trust was supposed to be split into 2 pieces. Half of the property goes into the B trust, the other half remains in the A trust. Then when the second of your parents die, the A trust becomes irrevocable just like the B trust was. What sometimes happens in cases like this is after, let's be stereotypical and assume dad dies first, mom never gets around to funding the 2 sub-trusts. Now, that's not a fatal flaw. It happens too often, but it does happen. And if nothing has changed over the years, there's probably no real issue with funding those 2 trusts. But if there's been some change to the A trust, so if mom, after dad's death, says, well, now I want to leave a piece of it to the grandkids, or I have one child who I don't like anymore, so I'm going to write them out, we may have an issue that turns into a conflict because you may get valuation issues. You may get issues about what is it that should have gone into the B trust back at the time that dad died. And is the trustee benefiting him or herself by assigning certain assets to the B trust as opposed to the A trust? This gets a little wonky. I'm not telling you that simply because there was a failure to fund, there's going to be a conflict of interest, but I can tell you if there's been a failure to fund and there's been a change to Trust A, this is something you ought to at least investigate. So if your trustee has a conflict of interest, you've got a good basis for removing that trustee.